project, in particular the legal dimensions of it. The first and most important step is to introduce all the members of the legal team. We're going to walk through and talk about the contract itself between the association and the developer. That document is available to everyone. It's going out with your invitation for a meeting, but if you want it before that, you can get it. Then we're going to talk about the legal framework and the timeline and how these pieces fit together. What has been put together by the team here is a incredibly creative way of accomplishing something that nobody's ever done. Nobody has ever tried to develop a property and allow the residents to stay. And consequently, the legal framework to do that had to be invented, and these folks did it. So they're to be applauded. It's a very creative solution. It's very smooth and elegant, and we're going to walk all the way through that. And then we're going to talk a little bit at the end about the bylaws and governance and how that fits into the picture. So roll up to the next slide. Okay, so we got stuff on our screen here. Can you clear that up? Like lower right side stuff? There we go. Okay, so anyway, Ed and Claudia Lopez here. There are our association counsel. They've been working with us for quite a few years. Ed, how long has it been?
Since 2010.
2010, yeah, that sounds about right. 12 years. He's sort of the corporate memory. He knows where all the bodies are buried. Claudia's more recent, but I've been working a lot with Claudia lately for a variety of different reasons, mostly related to collections. And so their role really has been to review what's been going on all the way through and make sure that we're staying consistent with what's allowed in the bylaws, what's allowed under the state law, all those kinds of things. Ed's going to be doing the drafting of the final voting instruments. We have drafts of it. He's finalizing those. And coming up with a method for tabulating the votes. An independent company to do that, like Price Waterhouse does the Oscars, same idea. It's not Price Waterhouse, they're too expensive. But hopefully we'll be able to do that both with forms that you can download and fill out and also electronically. So he's handling all of that stuff. And primarily looking at everything else that goes through, the contract especially, but also the legal framework that primarily Mike and Walsh Colucci has put together to make sure that it is consistent with what the bylaws say and make sure that the interests of the association are protected. And that's a key point to keep in mind. None of these people is here to provide you with legal advice. Absolutely none of them. None of them can. And especially not either Mike or Churchill, because for them to advise you would create a conflict of interest. And that would open us up to a whole can of worms. So you can't talk to them directly in the sense of asking them. You can ask questions here, but I mean, I'm not going to be able to give you their email address. You're not going to be able to call them up on the phone. We can't do that. What you will do is if you have things that you would like and they need to answer, you should push your questions to Ed. Ed will tell you if that's a personal issue versus whether it's something the association's attorneys can address, because that's the association, that's not you, okay? The association is all of us as a collectivity. Your personal interest, they can't advise you about that. But if they think that that's what it amounts to, they can provide you with a reference to lawyers who can help you if you want, or if it's a question that they feel is appropriate for those, they will pass that through and get you your answer, okay? So that's their role. And they're also, as we go forward, they're going to be keeping tabs on the actual management of the project and how that unfolds to make sure that we're staying within our bylaws, because that's going to be the controlling document all the way through. We're still going to continue to vote on everything the same way we are, same way we always have. None of that's going to change, even when we get into the new condominium. And then they're going to be assisting in the final stages when we actually implement the new condo. They're going to make sure that our new bylaws are consistent with what we started out with, because it's going to be the same bylaws. We'll talk about that at the end. Okay, next one. So Huff Law, this is Churchill Huff. The firm was founded by your father, I believe?
No, by me.
Pardon? Oh, you found it, okay.
Yes.
He has been retained by the association to represent us in the contract negotiations and putting together that contract. He's done a lot of work with a a lot of different development deals and things of that sort, so he's very experienced. He's also very fast. He's one of the most responsive guys I've had to deal with in this whole process, no offense to the rest of you. So primarily, again, he's been responsible for the contract language, and then he advises on the process and the strategy to make sure that the contract and what Michael has been putting together in our bylaws make sure all of this fits together. So if you're asking, if you've been wondering why it took us from January to July to get this in place, that's why. Because every single change that got made anywhere, all of these people had to go through that stuff and make sure it fit in from their point of view. It's a very complicated thing. It looks very simple when I diagram it and walk you through, and it all looks very easy now, but getting there was a very complicated process. And these people have been great the whole way through. I've just really enjoyed working with them all. Okay, move to the next slide. So then Mike Kiefer works with Walsh, Colucci, Libley, and Walsh. They're called the land use attorneys, and you could almost like capitalize that. In Arlington, they are the best land use attorneys and have been for many, many years. So Mike and Tom Colucci pulled together. Whoops, we lost our screen. What happened? Why is that happening on my computer? I'm not doing anything to it. It's just sitting here. Why is it doing that?
Might have been a chat popped up.
Yeah, I think somebody may be trying to send me a chat or something. Oh, okay. All right, so they were retained by the association to represent us, and Michael and Tom have been the ones primarily putting together this whole legal framework and architecture to make sure this all happens. And they have or will be drafting documents to handle the termination, which I think that one's already done, right? Then when we go to create the new LLC, and when we get to put together the new document, the new declaration and other documents for the new condominium, that will be what they are primarily taking care of, okay? They were gonna continue all the way through. They're gonna kind of manage the process again to make sure that we do all the steps, dot all the I's, cross all the T's as we go through this. And then they're gonna handle the actual declaration of the new condominium, filing all that paperwork, all those things, and making sure that that all gets done in a timely way. So, dang it. Is there any way we can keep that from happening? Say what? I can't even figure out how to get this back up on the screen now. There we go. You lost internet? Oh. Okay, so can you move up to the next slide? No, you can't. Do we have no internet at all? I'm not. I'm still looking at the last slide. He's moved it there, but it hasn't changed on my screen. Don't you love technology? So I'm not getting you up there. You've moved the slide, and my slide hasn't moved. Okay, so anybody, as long as we're at it, anybody have any questions so far? Do we have a problem with the connectivity and the Wi-Fi here? You're right, the Wi-Fi is out. Hold on. Our Wi-Fi is out. Where was? Okay, it's AHC_5GHZ. Yeah, but the problem is that I have no idea where I stored that password. It's all automatic on my stuff. Hold on. Sorry of you folks out on Zoom. We had a disconnect with our Wi-Fi here. Okay, now we're back to the new slide. Oh, it disappeared again. There it is. What? Is it locked now? Okay, good. I'm sorry, who's that, Dan? Oh, Mike, that's you. You need to park the other way. You need to park lengthwise. Yeah, no, this is Mike here. Our audiovisual guy was blocking somebody in. Wonderful. Okay, well, we'll be on this slide for a little bit. Hopefully he's back in time. So the contract with the developer defines the transaction between the associate, the co-development contract defines the relationship between the association and the developer in the process, in the project. So the basic core of it, as you all know, we're exchanging some of our land to get a new building. We're not going to get into the details of what's being done there. Okay, this is the legal of the how, not the what. So it defines the building and the units that are to be delivered in great detail, and it establishes various performance requirements and penalties, particular milestones that have to be met, things that have to be done on the way in terms of status reports, things like that, and then what the penalties are for that. And to kind of sum it up, basically, if we don't like what he's doing, we can fire him. He doesn't have any control over any of this. We control the whole process. We control all of the products all the way through. He receives nothing other than expenses until the building is done. Okay? Only then does he get anything. So people that were concerned about, is the developer going to be cheating us out of something, whatever, going to have an opportunity to do that. He doesn't have anything. He literally has nothing he can do until he delivers the building. Everything else is under our control. In addition, the one point of risk in this contract, or what I would call high point of risk, we need a developer in order to get through the county planning process. Okay? That's really the key part of it. The county won't talk to us without a developer. The architects, the engineers, even the lawyers don't want to talk to us unless we're working through a developer. Okay? They don't want to have to deal with 110 opinions. That's the bottom line. Okay? They want one point of contact, one person that has the authority to do business. Okay? That's why we have to have that developer. Carl is required under the contract to represent us through that point, no matter what happens. If the county comes back and says, sorry, we're not going to let you have all the units you want, he looks at it and goes, I can't make any money on this anymore. he still has to represent us all the way through that process anyway. Okay? So he's required to do that. That takes us through our most critical point. Once we have that plan approved, we actually don't even need a developer at all. In fact, as Craig pointed out when we were doing all of this, he said, you know, if Carl went bankrupt, once we had this plan approved, if Carl went bankrupt or just decided to stop showing up, we'd actually be better off. From a financial point of view, we would actually be better off at that point. So he's required to represent us and take care of that through that point. The contract also provides that the units are delivered for a fixed price to us, no matter what happens with the pricing, no matter what happens with inflation, anything else, okay? The good news is that protects us. That was one thing that everybody wanted to be sure of, that the price wouldn't go up, that you know, after we enter this contract and he'd come back and say, oh, well, this thing went wrong and that thing went wrong and I have to charge you more. He can't. And I can tell you right now, he's already absorbed almost $1 million in additional costs since we negotiated that price. I'll get to that when we talk about Bozzuto. Okay? The second law firm? Okay, the first law firm that we're talking, who worked with the contract with us for this was Huff Law, Churchill Huff. The other one is Walsh, Colucci, Lubley, and Walsh. They're the ones that did the legal framework. And then our in-house association counsel is Whitford, Taylor, and Preston. Did I get it right? Whiteford, Taylor, and Preston. I'm getting better. I almost always get one of those names completely wrong. Okay, so another important point in the contract and in this process is our land is never at risk. At no point in time is our land subject to any collateralization for any loan or anything else, no matter what happens in this project. If we went to war with Russia and this entire thing imploded, our land would still be our land, okay? Also, there are potentially a few units that the developer may acquire in our new building because of the way the buyouts work and the timing, okay? Anything more or less in the first 2 years, any buyouts that happen are to his advantage. The plan is basically he just puts a fewer units in our building and he moves those over into his buildings, right? But at a certain point in time, when you're designing a building, at a certain point in time, you can't just arbitrarily decide, oh, we've got another buyout, let's take one more unit out of the building. At a certain point, you're going to build the building you have. And so he may wind up acquiring a few units. He's not allowed to do anything with those. He doesn't get to vote those. He doesn't get any claim on our reserves from those. He can't rent them. All he can do is sell them once the building delivers. Okay? And he's very generously said, if anybody wants to exchange units for ones that he has acquired, somebody wants to go from a 1-bedroom to a 2-bedroom and he has one, he's perfectly willing to exchange those. Okay? All right. Next slide. So the contract specifies both the building and the owner's unit requirements in the detail of Exhibit C for those of you who are looking or have looked at the contract. It's a very lengthy list. Everything any owner here said they wanted is on the list. He's agreed to everything. Okay? Well, he didn't agree to give me my bidet. That got thrown out. That's going to be an added cost. But basically, everything people asked for, we got. Balconies, hardwood floors, you name it. Okay? Now, the specification says that the building will be substantially similar to the Trove. This was how we dealt with the question of the quality of the construction of the building, okay? Rather than try and go through an extraordinarily complicated process of specifying every single technicality of the building, we said, build us one of those, because we know the quality of what that is. And we built the rest of the contract around that, because Bozzuto is the one that built the Trove, and they're going to be our builder. KGD are the architects that designed that building, and they're our architects. Okay? And there's a lot of reasons why that also eliminates risk, which we'll talk about. Now, we're not done. There are a lot of things about this that people have objections to. The biggest objection, of course, that we all have is we don't have to pay $72,000. But there's other things that will get added in. We're still negotiating. In fact, one of the reasons I could get in a digression with some stories, but let me just say this. Craig's reputation, okay, his MO, the way he does things, okay, his attitude or his philosophy is, okay, great, we've got a signed contract, let's renegotiate it. Okay, we're not done. Okay, this contract is only going to get better. Okay, but where we are now is extremely good. Okay, KGD Architects and Pizzuto are going to do work on the building. That further reduces risk. They both, KGD, I said that, KGD designed the building, Pizzuto built it. This minimizes revisions later. What ordinarily happens in a development process is you design a building, you get it approved, then you go out and you put out bids to find a builder. And you get these bids in and you select the builder, and the builder comes in and he looks at your plans and he says, no, you can't do it this way, you can't do this, you can't do this, we have to change this, we have to change that. That means all of your plans get revised, your costs all change, and in some cases, in the worst cases, you have to go back to the county and get approval again. We eliminated all of that by building them in on the front end. The second piece of the puzzle that's really, or third, is really important, is Pizzuto will post a performance bond, okay? Now what that does is, you remember I said our land will never be tied up. Normally when a developer develops a property, he uses the land as security for the loan to get the construction money to build what he's going to build. That's not what we're doing here. Pizzuto is posting a performance bond. So what happens is, they basically say, if we don't build this building for you and we don't build it at the cost we predict and the time frame that we agreed to, then our insurance company is going to pay for all of your damages. So as a consequence, the banks don't have to use our land as collateral, they use the performance bond. In addition, it provides us with a 10-year warranty on the building, okay? Pizzuto is one of the few companies that will give you a what's the right word for it? Bumper to bumper, if you will, warranty on your building, okay? They're gonna do a walkthrough with you to accept your building. They're gonna come back and do it again and again and again. Over a 10-year period, anything that you find that's wrong in your unit, they're gonna basically come back and fix. Now, of course, the appliances and stuff have their own warranties. This is talking about what's been built. Okay, if you put your fist through a wall and have a hole in your drywall, they're not going to fix that. That's your problem. But if it's any kind of construction defects, they will fix. With regard to that, when they started the process, and Craig can correct me if I'm wrong about this, when they started into this process and they started working with the design team, Pizzuto came through and said, sorry, we can't build this building. Because when we built this building, we had problems with shrinkage on the upper floors. Okay, that building was delivered in 2019. So they're finding problems up there now, 5 or 6 years later, what they call shrinkage, and I'm not quite sure I know what that means, but I think it means nail pops and drywall seams and stuff. So they said, so instead of this one floor of poured concrete, you're going to have 2 floors of poured concrete in your building. Okay? So it's a better quality building. They learned from the Trove. We're going to get the benefit of that learning curve, and Carl has to pay for it because that came into the picture after we negotiated the price. Putting another floor of poured concrete in the building is going to run something like $675,000. Okay, so that's $6,800 approximately that each of you are not going to have to add to the cost of your unit because we have the fixed price. And that won't be the first thing, okay? So that's the way this has been put together. So at this point, I'm going to pause and open the floor to anybody that has questions about the contract before we move on. Come on in. Alba, come on in. We got chairs up here.
Andy, there's a question in Zoom. It says, will owners who are renting out their units still receive the rental income during the construction period? If yes, can we get that in writing?
It's in writing in the contract. The answer is yes. If one of your units if you own a unit in a building that's being demolished, okay, then you will get a rent offset based on what your current lease is, okay, from the point where you no longer have use of the unit, which will be about 60 days before demolition, actually, until the time when you get your new unit or when you take the cash buyout, whichever you do. If you're in a unit on the west side with a tenant, and we end up needing that unit to house an owner-occupant from the east side, you will similarly get a rental offset payment based on your current lease so that you don't suffer a drop in income. while the occupant is in that unit until you take your new unit or you take the buyout, whichever happens. Any other questions? Churchill's up here waiting. Yes, that has not changed. No. Okay, so yes, the question is if someone just wants to take the buyout and not wait and get a new unit, is the buyout amount still the same as what's been discussed? The buyout for a one-bedroom is $274,000. For a two-bedroom, it's $280,000. That buyout is available to you more or less from day one after we approve the project. It'll take a little time to set up some administrative stuff, but you can elect that buyout from day one, and you can decide when you leave, as long as you leave before the demolition happens. When the demolition will happen? It should be about 18 to 24 months, maybe worst case, 27. I mean, it has to be no later than 36 months, but it's very unlikely to take that long. About 2 years, give or take. Yeah, you don't have to worry about anything for 2 years. This assumes that we approve it, and for talking discussion right now, let's assume that we approve things and the project starts January 1st, okay? Just to make life simple. It may be December 1st, it might be February 1st. Let's, for a moment, say it's January 1st, okay? Assuming that's the case, demolition is not going to occur before probably about January 1st, 2025. Yes, absolutely. We are setting up one-on-one interviews with people to walk through the process in a little more detail and look how it affects your personal situation. If you are going on and you're going to need financing, we model the financing for you so you have a sense of what your payments are going to be, and then we walk you through the voting process. Everybody should have received an email asking you to log in and fill out a form to set up an appointment to do that. Okay? When you do that, I mail you a whole set of all the important documents you need to review, including this contract and some other things. Anybody can have that without the interview. I'm not trying to restrict access to it. Just that's the easiest way for me to keep track of who's been talked to, who's had this material. I don't want to send it out to everybody because then I'll get all these questions coming from people all the time in email that they're going to get answered if they will just sit down in the meeting. Okay? And that I don't have time to deal with 100 people sending me emails every day. I hate to say that, but it's true. But does that answer your question? Okay, so no, the project will begin January 1st, but nothing will happen from the standpoint of demolition or anything like that until 2025. Okay? Because what's going to happen in those first 2 years is doing all the design process, getting the site plan approved from the county, and then moving on and actually designing the building, the blueprints, getting the county to issue the building permits, all that stuff. That takes a couple of years. None of that stuff begins until we approve the project. Costs too much money. We want Carl to pay for that. We want to pay for that.
But let me make one point.
Craig.
During that 2 years where you had the sense that nothing's happening because the building's not being knocked down, every morning when you get up, you can have $274,000 or $280,000. And then if you go past that, as the building's being built, that value just goes up if you decide to sell in the third year. So the project starts because everybody can wake up and know they have a lot more than their unit's currently worth.
Yeah, I don't want to get too sidetracked into this. This is about the legal process. You need to come to the, I bumped into you in the parking lot. You need to get, you and your mom need to get set up to do a one-on-one meeting, and we can walk through all that in detail. And you'll know exactly how long you have to decide to whatever it is, do whatever it is you want to do. Okay? But the important thing is you have time. Okay? It's going to be a couple years before anything happens. You don't have to make up your mind about the buyout now. You can make it up later. You don't have to make up your mind whether you want to take the early buyout or the late buyout, what you want to do about, you don't have to make up any, you got years to consider all those issues, okay? What we need to decide now is are we going to do this or not, right? But you need to set that up, okay? Because that's where you get really into the nitty gritty of what your plans are, what you want to do, okay? And how this project fits into that picture and the timing of things, all right? Go ahead. It's entirely dependent on how long you want it to take. To actually, from the point where you say, I want to buy out, how fast could it happen? Days. Days, literally. There's all kinds of things we don't have to do, okay? It's just like selling your unit to anybody else, except we don't have to do things like title searches and all those kinds of things that normally happen because we don't care. The unit's going to get demolished. All right? You don't have any closing costs. If you have do you have a mortgage on your place now? Okay. The $280,000, you'll have to pay that mortgage off with the $280,000. Everything else is yours. There's no closing costs, nothing. If you have no mortgage on your property, the $274, is it one bedroom or two? Okay, it's $274 then. Okay? If you got a one bedroom, the $274 is yours minus your mortgage. That's it. Now, you might not want, one second, you might not want to do it in a few days because what you'll get is a signed contract, which is called a non-contingent contract, okay? It's just like cash. You need to find somewhere else to live. You can take as much as 2 years to find that because that contract, when you're negotiating, that contract is just like cash. The bank wants to know how much you can put down. I can put down $274,000. It's right here on this contract. So you have time. You get to decide when it happens. It only takes a few days to set it up. Okay? Yes, sir.
No, with that, you said that you received 274,000, right? One bedroom, and then you have to pay your existing mortgage, or you're gonna deal with that.
They will take care of paying it. They'll get from you who your mortgage company is. They'll make all the arrangements and so forth. I'm just saying you have to deduct that. You have to deduct it from your 274. You don't get, you have to pay your mortgage off when you sell your unit, okay? They'll take care of all of that. Whatever entity, that's why I say it may take a few weeks to set up the administration because we have to set up somebody that'll do all that for you, okay? There are people that do that for a living, not me.
That's mean we continue with the process. When we know that the 80% is reached that point.
That depends a little bit on Ed and who he gets to do the tabulating and what their parameters are. But in general, what we're trying to do is keep track of those percentages on a running basis. We can't actually see your votes. That's the whole point of getting an outside person to tabulate the votes for us, okay? We can't see how each one of you vote, but we can hopefully get running tallies of how the votes are going, yes and no. And we will keep people apprised, just like I would do with when we were doing the interviews and the surveys. I kept people up to date on how people were responding to that question. And this will be people, how are people responding to the actual vote, okay? And once we cross that 80% threshold, then we'll declare victory and get to it. Who knows? Depends on how fast people get into their meetings, get their voting documents, go get whatever outside advice they need, and file the votes. I can't tell you how long that'll take. I'm hopeful that we'll get it done by November because that's what we're contractually obligated to do. The deadline, in theory, in the contract is November, okay? Now, Carl's not crazy. If we're getting good progress and we're getting close, then he's going to give us an extension. But I'd rather not have to do that, okay? We said we'd get it done by November. That's the best estimate we have from the best realtor we can find. When they deliver, they'll be worth about $450,000, correct? Hi, Corey, how are you? Plenty of seats, have a seat. Okay? Now, just on the subject of the buyout real quick, this really isn't a matter of the contract, but I want to underline something here. I don't recommend that you take the buyout in phase one. Yes, it's a very nice price. It's far better than you'll do right now if you tried to sell your unit. But you can make hundreds of thousands more if you wait. Because once we get to and you see this when we do the process, Once you get to phase 2, you have a contract to buy your new unit, okay? And you can sell that contract to someone. And that contract is worth a lot more than $280,000. Last resort, the association will buy it from you for $280,000, or $274 in your case for a 1-bedroom. We're still the buyer of last resort. That's still available to you. But you can have a realtor, or probably even yourself, you probably a classified ad out there, because you will have a contract to buy a unit for $72,000 that's worth $450,000. You can sell that contract for a lot more than $280,000. So if you can wait, you should wait. It's worth a lot more to you.
It says it's some restriction with that you sell that.
No, there's no restrictions. Up to the day before you take delivery of that unit, you can sell that contract. Now, you have to, yes. I'm sorry?
After.
Oh, yeah, you could sell your unit. You could take delivery of the unit and just sell the unit, okay? But then you're going to have to deal with the closing costs. When you sell the contract, you have no closing costs. You're selling a contract. You're not selling the property, okay? So maybe the properties, we talked the 1-bedroom thing, maybe it's worth $450,000, okay? 2 months before that unit delivers, you might be able to get somebody to pay $375,000, $400,000 for it. Maybe more, I don't know. Okay, but you're going to get close, as you get close to delivery of the unit, the price starts to approach the cost, the value of the unit, right? Anyway, I'm getting sidetracked. I didn't want to do that, derailing things. Any other questions about the contract for Churchill? Anything on Zoom, Liz? Okay, so let's go to the next slide then. We're going to get into the legal framework and process, and this is Michael's wheelhouse, and he's done a wonderful, wonderful job with this. So the first piece of the puzzle is creating an LLC that will manage the process, the assets, and the debts that go into this project. Now, this is just a bucket, and it gives us the ability to do things that as a condominium you can't do, okay? And it's a very elegant solution. Our association will be the sole member or shareholder, however you want to look at it, in this LLC, and your interest will be represented the same way it is now in the condominium. You have a par value that passes through the association, okay? You have a condominium that you own, that's your unit, but you have a common element interest that's defined by your par value. Same thing will still be true here, okay? All the project expenses for construction will be covered, and for the development, the construction, the buyouts, all of it. All of those come from loans that are made into the LLC. None of that is secured by our land whatsoever, okay? Once it's all done, Carl just takes the LLC. That's sort of the beauty and elegance of this. All of our assets, all of our debts go in there, our condominium comes out, and Carl's left with the rest, okay? We're gonna walk through that in detail. So in order to do this, we have to terminate the existing condominium. That's required because the condominium is what we have. Condominium is a very specialized kind of corporate entity, and really all it is a way of a collection of people owning property in common. It can't do anything. And once you decide you're going to knock down buildings, that definition is no longer valid. So the condominium has to be terminated. The LLC will then take control of all of those assets and hold those in trust. And again, you still have control of that with your par value. Your share of that is still represented by your par value. That hasn't changed, and it's not being collateralized in any way. Then the LLC ultimately will declare, well, actually, basically as close to simultaneous as we can manage it, when the termination happens, the new condominium will be declared. It will be called, it's what they call an as-built declaration, because we have a blueprint that defines the building and defines and gives us an address for every unit in that building. That's why we can write a contract to you, because you have an address, okay, for the contract, right? So that happens at the same time based on the blueprints, and then there's a parcel that's been subdivided out of our land that's whatever's required by the county for our condominium, whatever was approved in the site plan. They'll tell us you need this much green space, all that stuff. So that parcel of land will be cut out. That will be then declared and given over to the new condominium, along with the new building when it's ready. Okay? And then you get your contract. We will carry through essentially the same bylaws that we have now into the new condominium. I'm going to talk about that in more detail later. And I can't see the bottom of that slide, so I have no idea what the last bullet point is. Yeah, issues contracts. Right, we already said that. Okay, so go ahead and move on to the next slide, which is our process. I'm going to walk through this step by step so you see how this unfolds. But in general, does anybody have any questions to this point, or have I thoroughly confused everybody to where you don't even know how to ask a question? There's three pieces of the puzzle, okay? There's the new LLC that is going to hold all our assets and all the debt. There's the termination of the existing condo, and there's the creation of the new condo. Does anybody have any issues or questions right now about that? That's going to get more clear as I walk through the process. Anybody on Zoom? Okay, so I'm going to get up here and point at stuff. So this is what happens right after we approve this project, okay? Right now, we have our owners over here. We have our HOA, and we have our condo. Now, most of the time, we treat these things as if they were the same thing. We don't differentiate when we're talking about it. But they are, in fact, completely different entities, okay? So the HOA will create this LLC, and it will be the sole member. It will own everything in this bucket. Okay, we're calling it Arlington Heights LLC for the moment. All right, next slide. So when we get into phase one, TrustStar Bank is going to loan us $3.5 million to cover all of our development expenses. And they're going to give us a line of credit to execute any buyouts for owners that want to go ahead and sell and leave. All right? So all the design and so forth is being done and fed into this because we're paying for it, we own it. Okay? So anything that happens, all of those things, we own and control all of it. What's going on down here is everybody here is participating in getting the design done. I show it here because these are the people that will be feeding to the county and giving us documents and things, okay? But Bozzuto is in there because they built the building, so they're going to be contributing to that whole design process to make sure that what comes out the other end is something they can actually build for the money that we're asking. Carl's in there because he's the person responsible for the whole site plan, okay? Because the whole site plan includes not just our condo, it includes the 62 and over building, it includes the apartments. So he's got all of that he's got to feed into there. And then in addition, he's got to make sure that what they're doing complies with what he's required to deliver in the contract. So this is a team of people all working on this, generating output that goes ultimately to the county, and we own all of it. Okay? Next. Now, when we get to end phase one, and we're going to be preparing phase two, we're going to be knocking down buildings. So before that happens, we have to terminate our existing condominium, and those assets get moved into the LLC and held in trust there. You still have your share. It hasn't gone away. If everything blows up, your share is still right there. It isn't collateralized. There's no loans holding. There's no loans that use this as collateral. Now, this is when Bozzuto posts that performance bond, that crucial piece of the puzzle. Okay? And then that allows Sandy Spring, and then also TD Bank is in there as well, because TD Bank's providing the lending for the 62 and over building. So TD Bank and Sandy Spring, they can loan the money to actually do all the building. The relocation has to occur there, moving people over to the west side, okay? And of course, we've done the declaration here, so we have our new condominium, and this has issued contracts to all of our owners to buy units in that new building when it's delivered. Now you can sell your contract. You have a contract, again, a non-contingent contract for $72,000 to buy your new unit, and it's a specific address, because what's going on here that we're not going to talk about today is we've all gone through a process to choose our units. Let's not get sidetracked with that. I know it's a hot topic. So any questions here? Everybody clear about all this? All right, next slide. So now we get to the end of phase 2. So Bozzuto's finished building the building. They formally deliver that along with their 10-year warranty, and those become the property of the new condominium. So everything that's left in here are the remaining designs and things for the rest of the site plan, the value of all of those buyouts that have happened, all the line of credit for that, all the development costs that were incurred to get the design plans and permits, all the relocation costs, all the construction costs, and the remainder of our land. That's all that's left in that LLC at this point. Okay with that? Clear? All right, next. So, the final step to complete the project is our existing homeowners association passes the membership of that, sole membership of that, to Carl. So he now has all those expenses, all those loans, all the interest that's accrued. We've not paid a dime anywhere for any of that. And then he owns the rest of the land that we agreed to give him in exchange for our building. We're done. We're off in our own little world. We have our own little condominium, same as it has always been. Nobody else owns any. Well, Carl may own a few units in there that he hasn't sold yet, but the only thing he can do is sell them. He can't vote on anything. He gets no claim on our reserves, any of that stuff. Okay? That's the end of the process, and the project's completed, and we're all living in our wonderful new places. Okay, any questions? Yes, Jerry.
The 72,000, that is not, now it's not necessary until everything's completed?
Yeah, yes, that's correct. I'm glad you asked that question. People have been very confused about this. The 72,000 isn't needed until you get to the very end and settle on your brand new unit. Okay? You don't have to deal with any of that. Now, when you sit down in your meeting, you'll see we can finance that. Many of you, if not most of you, will actually be paying less in total for your mortgage condo fee combination. You'll be paying less than you are now because condo fees are much lower. Not everybody, but most people, okay? Some of you have stupidly low interest rates. I can't, whatever. Point being, it can be financed in a way that you can afford. But you don't have to come up with that 72,000 until the end, the very end, right? Literally, when you sit down and buy your new unit, that's when the 72,000 has to materialize. Okay? Thanks for asking that. That's something that a lot of people, I think, have been confused about. Any other questions? Anything coming in on Zoom? I'm surprised. I thought people would have more questions. I'd love to think it was a credit to how clear I'm making everything, but I doubt that's the case. Okay. Yes. Had their meeting so far? I think around between 25 and 30. And we've got another equal number at this point that are just scheduled. They haven't come in yet, but they're on the calendar already. A total of somewhere between 50 and 60 people. Those will be done, that's basically another 2 weeks. So that's where we are in the process. This is, by the way, very much exactly what happened with the briefings, too. We got a whole slew of them at first, and then the next month, in the next month, it's just a little bit at a time. It slows down.
If I understood correctly, you're gonna close everything we have now, like the condo fee, everything, condo fees and stuff, and we're gonna have the new mortgage only with the new existing mortgage.
If you need a mortgage, then you will have a new mortgage at that point. You will still have condo fees, but they're going to be much, much lower than they are now. We're estimating in the new building at the moment, our estimate is that your one bedroom will have a condo fee of $325 a month, and a two bedroom will have a condo fee of about $375 a month. Okay, now we won't know that for sure until we get further along in the process. Until we have blueprints, really, you can't really get a handle on what those costs are going to be precisely. We got a bit of an idea because we know what the cost of maintaining the trove is, and we know what comparable costs are for other condominiums. But there's things that just don't match up. Most new condominiums have things like fitness rooms and stuff. We will have a fitness room. We will have access to the fitness room on the other parcel on the west side. We don't pay for any of that. That's all free. That's part of our contract. okay? We get access to the fitness room, swimming pool, we get extra parking in the 62 and over building. I mean, there's a lot of stuff that's built in that we're guaranteed in perpetuity. They are easements issued on the actual titles for the land, on the deeds. And they can't be changed. If they sell the property, those are still there, okay? So there's a lot of stuff like that that most current condominiums that are out there, they have them, and they're paying for them in their condo fees. We don't. So it's a little bit tricky to try and get to an estimate. Okay, anybody else? Okay, well, I'm going to summarize really quickly, and then I'm going to ask a couple of questions of the attorneys myself. In general, where we are is this. A lot of concern was voiced in the process of the briefings that we were doing, in all the meetings that we had leading up to even talking to Carl in the first place, okay? And then subsequently, about controlling risk. This is, for most of us, it's the biggest investment we have. It's our home. It's where some of us have lived for more than 60 years in one case, Mary. So it's scary. We have gone to extraordinary lengths to make sure that you have as little risk as possible. There's no such thing as no risk, ever, okay? There's not no risk in not doing this. There's a lot of risk in not doing this. The risk of what will happen to these buildings as they further deteriorate. So there's never a point where you can say there's no risk. But we've gone to extraordinary lengths to put the boards around the sandbox to make sure that Carl can't do anything that will adversely affect this, okay? And to make sure that at no time are our actual existing assets at risk through this entire process. And that's pretty unusual. If you went out there today and you said to a developer, look, I've got this great idea, we're gonna redevelop a condominium property. What do you think? They would say, no, I don't do condominiums because I don't have to deal with 110 people who can't make up their mind. Most developers think that we can't do this and they don't even want to talk to us. But if you went to them and said, I've got this idea to do a redevelopment project for a condominium and it's innovative and it's never been done before, they wouldn't tell you no. They'd turn around and run. Because developers hate risk. Sounds crazy because development is a very risky business. But that's why they hate risk. They don't need anything new. They don't need anything new. They want to do something they know exactly how to do. That's why we never got to a deal with Bill Benson. He could never see past what he knows how to do. Okay? Carl bent over backwards to do this with us. No developer in their right mind, and this, Churchill, would you agree? You've never seen any developer that would accept what we've done here.
This is certainly a very unique and creative process to get there.
It's unheard of, okay? And developers don't like to do things like that. So for those people that don't like Carl, you can continue to not like him, but I don't know that there's anybody else out there that would actually, that we could actually pull this off, okay? And there's reasons for that, and if you want to get drill down on all of that, I can hand you some, and Craig can hand you more. But the point is that he's bent over backwards to work with us. He's given us everything we've asked for. He's made sure that he has absolutely no say in any of this. He's the one that has all the risk. Because at any time we can say, yeah, we don't like you, bye. And he's sunk all this time and energy into this and gotten nothing out of it. He's gotten his expenses covered to a certain extent, but he hasn't got anything out of it, okay? Now, Mike, if you can just talk just for a minute or two about how the framing of this is going to help us, how it protects us, just so it's more than just me running my mouth here.
Also, the initial process of creating an LLC that you're gonna, through your association, control, is the means by which I think you take, the most control of the process. In other words, you're not turning the property over to some developer or some other entity that you don't have a say in. The LLC is governed by, when it's created, your association. And so until such time as the new building is constructed and those units are sold to the unit owners who stay, you'll have control of the real estate here. And then once the termination occurs and the new condo is built and you have purchased your units in the new building or you've taken a buyout, it's only then that Carl comes in and actually takes ownership of anything. And so that was sort of the first critical step to us, was to say, okay, how do we protect your ownership of the real estate while all of this is going on? And that was the initial step. Okay. Secondly, we didn't want there to be a large gap between when the condominium was actually terminated and when the new project was begun. In other words, demolition. And so what we have tried to formulate is a timeline by which you can approve the termination, but then there can be a lag in time before we actually legally terminate the condominium. And during that time, the developer will get his governmental approvals in hand and be ready to demolish the first building, so that all of these things that Andrew has been explaining can sort of happen at the same time, so that you're seeing all of the termination, demolition, and then all these processes happening in a very small period of time together.
Okay, thanks. All right. So any last chance questions
Yes.
for this? Yes, go ahead.
Okay. One of the questions on Zoom says, Exhibit D of the contract, where it has sample floor plans, can we have them build something different, or can we only choose from those? For example, a 1-bedroom made into a 2 on their sample plan doesn't make sense because it eliminates the entire living room. Or would changing that piece require our own contractor post-construction?
Well, now you're getting to a question that's really almost a Carl question, but those designs were roughed out quickly, very early in the process, because people said, well, can I get a 2-bedroom? And the answer is you can't get one necessarily. To kind of digress a minute, if you have a 1-bedroom, you are going to be slated for a 1-bedroom. If you have a 2-bedroom, you're going to be slated for a 2-bedroom. And that's because we're going to the county and saying we're not building new units here, we are building replacement units. Okay? If we were building new units, we would have to build 20% of them for affordable housing, and those would have to be in our building. Okay? And that would screw with the economics of this really badly. Okay? So we're going into the county saying we're not new units, we're not new construction. We're just building new units for ourselves on our own property. But to do that, they have to be replacing what you have. Now, we're going to have, in the end, some 2-bedrooms that will become available for people to exchange, because people will take buyouts. Okay, Carl will wind up with some, and so forth. There's actually a few unit owners that want to trade from a 2 to a 1. Okay, so we'll have some exchanges. We're only building the same number of 1 and 2 bedrooms as exist here already. So some people say, well, if I can't get an exchange, how can I get to a 2-bedroom? So we had them design a space so that you could have, and nobody can see this, but if you look at that diagram, you'll see there's a differentiator where you put a wall across to create a 2nd bedroom. And I agree, it messes up your living space. Now, a lot depends on your lifestyle. I mean, it shows a dining room in there. You wouldn't necessarily have to have a dining room, depends the way you live. You have an eat-in kitchen there. So I'm going to do that, okay? I'm going to do it in such a way that I have double pocket doors, and this is going to be a flex room. When my daughter's here, she'll use it as a bedroom. When she's not, it'll be part of my living space. But that particular modification is available within the context of the contract. It's a $5,000 addition. If you wanted to do it some other way, maybe you want to obliterate the entire wall space on the interior, not including any load-bearing walls. Maybe you want to completely rearrange the interior. You can do that, and Carl will do that for you. It's going to cost you. That's not a standard unit. That's going to be, it's going to cost you. You can do it later and have somebody from, your own builder do it later on if you want. That's up to you too. Did that answer your question? Yeah, Craig has thoughts.
So during the tent meeting, a similar question came up, and Eli Tucker was very concerned that he was not just going to be everybody's realtor. He also wanted real input into the design of these units to make sure that you got the most bang for your buck, whether you live there or whether you're going to sell it. One of Eli's idea was for both the one bedroom going to a two bedroom, the two bedroom going to a three bedroom, was to actually have, as they do in many European hotels, a wall that is a bookcase that pulls down to a king bed and goes back up. A Murphy bed, but they're on steroids now, and they look great. So Eli, Bizzuto, KGD, and you as a group, because you as a group don't go anywhere, are going to help with the design to make these the most valuable and most flexible for everybody. Carl has standards. One of the biggest things we got up front, because everybody had a 1, wanted to go to a 2, everyone with a 2 wanted to go to a 3, we made sure that we got Carl to give the plumbing, the stubbed-in plumbing for a 1 bedroom so it could go to a 2 bedroom. For a 2 bedroom so it could go to a 3 bedroom. So the infrastructure's there. Ideas need to keep flowing, but you're going to have Eli Tucker, who's on the street making sure that you have the best designs with Bizzuto.
So essentially, what is in the contract is not for sure exactly what your unit is going to look like, and you can do whatever you want within the walls of the unit,
Correct.
but it may be at more of a cost to the unit owner.
Correct. Just like any other condominium that you would buy, it's going to come with a standard configuration. And in any new condominium you can buy, pretty much, you can have them rearrange it. They'll gladly charge you $10,000 or $15,000 to rearrange your unit inside. Okay, and it's no different here. But what the point that Craig is making is, these designs aren't done. Okay, people said, well, what kind of space are we going to have? What's it going to look like? These are examples. Okay, they can start to change. As I said, Craig's motto is, we have a signed contract, let's renegotiate. Okay, this is all part of that process. Okay, you want it to be done differently. That's fine. Maybe what we need to do is form a little subcommittee from the board that's got design requirements. They'll take feedback from all the owners as to how they want these things to be rearranged, and we'll feed that into the design process. Okay, we control this, all of it. Okay. Yeah, we own the contract with Bizzuto. This is our building. We can make it whatever we want it to be. Okay?
Okay, so the next question is, do we still have to pay county taxes during the construction period?
Yes, and that's a little bit of a difficult question because I'm not quite sure how that pans out when the LLC owns the assets in common, the common element assets. I'm not sure how that plays out with the county. We haven't got the answer to that question. I would say if the taxes are going to go up significantly, we will figure out a way to deal with that. Now, when we get to the new units, then the taxes are almost, well, I'd say they're likely to go up, but not necessarily. We are applying for a tax abatement for the new development. But in the interim, before we get there, I'm not quite sure how that works out with the county. I don't think anybody really can answer that question until we put this to the county in our proposal. Craig, did you have something?
Well, obviously, the county knows, and the taxing authority is going to know, we're going to knock down buildings, be in a development period, be in a building period. So that's one of the things we're going to discuss with the county. During this period, why would we be paying for something we can't occupy? It's knocked down. So we'll go through that as part of the process.
Hopefully, they'll let us pay no taxes for that period of time. I do want to make some discussion about the county because they come into this picture. You have to understand that we can't answer those questions. The county can't answer those questions. They cannot talk to us until we have our 80% approval. Literally, they cannot legally talk to us. Now, you can talk to people and you can sort of say, well, hypothetically, and you can get some answers. But something that technical, no, they're not going to answer that question until they have a proposal on the table and they know that 80% of the owners here have voted to go forward with the project. Okay? So as much as we'd like to have all the answers, we can't have all of them. Okay? Anything else out there? All right, great. Next slide. So, whoops, that's not the slide. Ah, there we go. So what happens now with bylaws and governance? And what that means is there are actual bylaws, the declarations, and our policies and all of those things that make up what our condominium does now, how we behave, okay? So the goal here is we're gonna work under the exact same thing going forward. Nothing in there will change that we don't explicitly change by vote or that isn't required by law, because our bylaws were done decades ago. And some of that stuff may no longer be allowed in a new condominium. Hopefully that doesn't change much. But while we're managing the LLC through the process, and when we start a new condominium, the principle is nothing changes. Okay? So Rose, as some of you already know, she has been working for almost a couple of years now on cleaning up our existing bylaws, because they are a classic example of an accretion document. Stuff has been added and thrown on there decade after decade after decade. There are contradictions in there. There are duplications in there. There's stuff that's just flat out uninterpretable. So she has been working very hard for a couple of years on this. And she's gotten most of it done, and you can look at it. I can give you a link for that. So she's been cleaning this up and putting it into shape. This had nothing to do with the project. She tackled this on her own starting a couple of years ago, and it really did. But it's going to advantage us, because when we get to this new condominium, Mike is going to come up with pro forma bylaws and other governance documents and things. There's a bunch of other stuff that's not relevant to this discussion. He's going to come up with what's called pro forma. It's essentially just, I'd say, I'm picking a number, 80% of every set of bylaws is the same language. Nothing's really different.
Similar.
Yeah. And then there's the stuff that we do that's unique to us, okay? And so Rose is going to help merge in the stuff from our bylaws that's unique to us. And then Ed and Claudia perhaps will be doing a final review to make sure that when we're going, they have the originals, they have the corporate memory, they know what's been done, and then they're going to make sure that the new ones say exactly the same thing or have the exact same effect. So that when we wind up in the other end, from the standpoint of the people who live here, you're operating under the same rules and regulations that we've had all along. Okay? Some of that will change. We're going to explicitly vote on some of those changes, and when you come for your individual meeting, we walk through what some of those suggested changes will be. Okay? One of them is obvious. Okay? We're going to eliminate the par value system, and we're going to go to a square footage basis to assess condo fees. The par value system doesn't even make any sense now. It certainly will make no sense in a new building. So that's part of what changes your condo fees. That's one change that will be instituted in the bylaws. Some other things we'll be voting on, like, managing landlord-owned units, stuff like that. We're voting on whether we're going to continue to roll in our utilities and roll those into the condo fees, or whether we're going to be individually metered. Now, the county may settle that issue for us, but if we get the choice, we're going to vote and we're going to decide how we're going to do that. Okay, so there are going to be some things, and there'll be other things that come up along the way. The point is that the board is not going to tell us not going to tell you how this is going to work. You are going to tell the board how it's going to work. Everything we're doing, we are voting on. Okay? You are going to get your say in all of it, any changes that we make. But the goal is, other than what we vote on, or we have to change, it will be the same as what we have. Okay? Any questions? All right, Ed, did you want to say anything about that? Just comment?
With respect to the condominium insurance?
Yeah.
So what we're going to do is, Andy just mentioned, we're going to look at the documents to make sure that they're on par. They're substantially similar to what you have now, subject to changes that have taken place in the law or through the courts for the past 20, 25 years. But you're going to recognize the document. You're going to be comfortable with the document going forward. So there won't be any surprises unless there's a change in the law that we just have to address. But that information will be made available to you up front or in advance, so you're not caught off guard along those lines. Sorry about that. Is that what?
Face the other way.
So what I was saying is, the documents will be substantially similar to what you have now, subject to changes in the law along those lines and updated to address those types of issues. There won't be any real surprises in these documents. As Andy mentioned, you're going to use your common element interest will be based on the square footage of the units versus par value. So you simply, it's just a matter of math. If your unit's 1,000 square feet, you're going to divide that by the total square feet of the units, and that's how you'll know what your common element interest is. It's a much more equitable approach than your current par value system is now. So that's the idea behind it, to make it as simple as possible, but to work through that process. I do have one suggestion, if I may, Andy. You were talking about improvements to the units. One of the easiest things to do is do it during the development phase. Once you get the board in place, and you've got to go through a whole different process. Hence, during the development phase, it's much easier. So if you have ideas about the design of your unit that you'd like to implement, the time to do it is during the development phase. It's also easier on you because you haven't moved into the unit yet.
Yeah, that's a good point. Anybody that's, and I have been in this position, and anybody that's been in a position that where you wanted to change something substantially in your unit, move walls around, you got to go through the board and get approval. And it can be a massively difficult undertaking. You got to demonstrate all your contractors are board licensed and all this other stuff. It's not easy. If you can get it done before you move in, you're much better off. Jerry?
Maybe this was evident, but I didn't pick it up. But the par value, is that directly related to co-op?
Yeah. Nobody knows for sure because nobody was here when the co-op was set up. Yeah, I mean, that's my theory, because when you try and analyze par value versus some of the obvious things that would affect value, the square footage of your unit, how many bedrooms it had, well, the bedrooms pretty work out. One bedrooms pay less than two. That's pretty consistent. But the floor you're on, the building you're in, none of it maps to or has any impact on your par value. None of it. Right, when you bought a co-op, you got chairs. And well, that's my theory, is that the original par value was tied to because the original co-op was actually set up by a bunch of World War II veterans. And they were pooling their benefits to create it, okay? And my guess is that it has to do with who's putting how much into that original configuration of units that determined the original par values. They've been modified some because we created some new units and some other things, but basically I think that's the core of it. That's my only guess, because otherwise there's nothing that makes any sense about it. But the point is it's massively unfair, and there's no way to change it, because no matter what you want to propose, somebody's going to be paying more and somebody's going to be paying less, and the people who are going to be paying more are going to vote against it. So you never get the 2/3 necessary to pass that change. This, everybody's back on the same footing. Everybody's going to have so much lower condo fees. No, the equitableness of it is obvious, and I don't think anybody really would object to it. Did you have a question?
Okay, there's another question on Zoom.
Yes.
We do understand that people will be voting as they have their individual meetings. However, is there a vote day or a deadline for votes?
Okay, let me clarify one thing. You are not expected to vote when you come to your individual meeting, okay? I mean, if you want to, I'm not even sure you can, because you have to have a witness, and that has to be an independent witness. Say what? Well, those are coming, okay? That's just a matter of Ed finishing up his drafting work. They're not ready right now, but they will be ready before all of these are done. But no, you're not expected to vote at that meeting, okay? I don't want anybody to think that they're going to walk into here and there's going to be some sort of, pressure on you to sign or something. None of that's happening. You're going to walk away, right now, you're not even going to walk away with voting documents because they're not ready. But even when they're ready, you're going to walk away with a set of documents and instructions on how to file your vote. Okay? At that point, if you want to seek outside counsel, as we've said repeatedly, you can go seek outside counsel. We will provide up to $500 reimbursement. If you want to go talk to your brother-in-law, whatever you want to do. Okay? If you want to file it right away, that's fine. Go find yourself a witness, sign it, and file it. But nobody's going to ask you to vote when you come to this meeting. The point of this meeting is to resolve any of the questions you have so that you understand everything you need to know about it so that you can make the decision that is right for you. Okay? Nobody else can make that decision but you, and nobody's going to ask you to make that decision until you're ready. As far as the deadline is concerned, we have a contractual deadline to complete the voting process by November. And we want to get as close to that as we can, if not exceed it, because we're contractually obligated to do that. And Carl is not obligated to extend that. He probably will, as long as we're making good progress. We're getting close. He probably will. He's a very cooperative guy, and he wants to do this. But the more delays we encounter, the more this entire process is going to drag out. A month's delay now can translate into a 6-month or more delay in the actual delivery of your unit. Think of it this way. The first step we have, the most important step, is getting approval from the county. If we don't get the plan to the county until June or July of next year, nothing will happen before September because everybody's on vacation. So we've lost 2 months already. If we don't get to the approval for the building and beginning the demolition until November or December, nothing will happen until March because you don't dig foundations in the wintertime. All of this, so 1 month now can wind up being 6 months or more at the other end. So what I tell everybody walking out of that meeting, take all the time you need to make your decision. But once you've made the decision, vote. Don't procrastinate. Don't put it off until you have a chance. Get it done and get it in. Because the sooner we get this process started, the sooner that you can start realizing the benefits. Because your condo fees are going to go down as soon as we start. Your condo fees are going to go down 30% or so. Day one, January 2023, or maybe February, depends on how long GHA takes to change their system. But basically, right away, your condo fees go down. If you're struggling with a really crappy interest rate on your mortgage, you can refinance your mortgage right away. You don't have to wait. Okay? So there are benefits right away.
Okay. So the next question was, how do you legally push along anyone who is unresponsive to the project so that the 80% can be reached? Or will there be a way those votes will not be included for completely unresponsive parties?
Okay. We will not reach unresponsive parties because they're being unresponsive, by definition. We have, I would say, something like 20, I don't know, because Mike's been working hard on this. He's knocked a few of them out. So we got somewhere around 20 owners that have not responded to things. Most of these owners, I think, are probably people that are actually landlords that we don't know they're landlords, so we don't actually have their contact information. But point being, I'm pretty confident we're going to get to 80% without them. Because if you go back and you look at where we were with the surveys, we had only gotten to about 80, I think, if I remember correctly. We talked to 80 owners, and we already had 73% of the par value. So we're very close anyway. And nothing in these one-on-one meetings has changed those numbers. Everybody coming out of these is expressing the notion that they're going to vote in favor of it. So I'm pretty confident we're going to get to the 80% without even having to talk to those people. But there may be some that we have to reach out and go to some extraordinary efforts to get to. Hopefully not. But we don't have to have all the votes of everybody. We have to have the votes that define 80%. Okay? So to be clear, once we reach 80%, I'm not going to be spending any time trying to get people's votes anymore. It's passed. And we're going to move on and start the project. And we will have to catch up with those people so they understand what's going on, because at some point, they're going to have to move out of whatever unit they're in. And we don't want that to come as a shock. So we're going to have an outreach process, and I haven't figured out what that is yet. I've got too many other things to deal with now. But eventually, we're going to have to deal with those folks, but we don't need them. I'm pretty comfortable we don't need them to get to 80%. And once we're at 80%, we're done. We're not collecting any more votes.
Okay. When do you think we'll reach 80%? What will happen if we don't reach it by the deadline?
Okay. I believe that we can reach it by November if we're really, really good and owners cooperate and they get things done quickly. But if we don't, then we will go to Carl and we will ask for a 30-day extension. And he will probably give it to us. It's possible that he won't. It's possible that he will say, no, sorry, you guys have just been jerking me around and I'm done. But I don't think so. He's been very, very cooperative all the way along the way. And he also is cognizant of the fact that, Carl wants to do this, okay? So he's not going to just arbitrarily decide to bail, okay?
Okay, next question is, I thought we needed a special meeting to obtain a membership vote.
Ed, that's a you question.
You do not need a special meeting. What you need is 80% of the owners to ratify the termination, the plan of termination. And that's going to be done by a written ratification form rather than trying to use proxies and ballots, because it's clear, it's more succinct, it's easier to understand. So that's going to be the approach. There won't be a specific meeting date. There may be a kickoff meeting or information meetings, but it's going to be a ratification process rather than a vote.
Okay, next question. Also, if par value makes a difference in our options ballot, where can we find our par value or where we fall in that value?
Excellent question. That came up in a few of our initial meetings. I have constructed a table of the par values, and anybody that wants to know what theirs is, I can tell you. But I'm not going to mail that table out because it's, your par value is your personal business. So if you need to know, you want to know before your meeting, send me an email or call me up on the phone and I'll tell you. Otherwise, come to your meeting and I'll give it to you there.
There are no other questions right now.
Okay, good. Oh, nope, here we go. Yes. Wait for the mic, wait for the mic, wait for the mic.
So assuming that, thank you, I will hold it. Assuming that, it will go through, then we don't have any financial liability. What if this doesn't go through? What is the financial exposure of the owners and the homeowners association?
Excellent question. In 2018, we put a proposal at the December annual meeting, we put a proposal to the membership to undertake and go forward and explore this process. And we said we're going to have to spend money to do it. We have to figure out what kind of densities we can expect. Okay, we're going to have to hire lawyers and stuff. Okay? The proposal was we would use the existing remaining co-op unit to fund that process so that if it goes through, then all of that gets covered by the development loan, okay? But if it fails, then we sell that unit and that will pay the money back that we've spent. Now, that will impact us in a very minor way. Liz can verify this, but I think we're getting $600 a month in rent from that unit. So that probably affects your condo fee by about 50 cents a month, something like that. But basically, it doesn't have any real effect. We sell the unit, and I have worked really hard to try and keep all of our numbers under that budget. So we're still fine, okay? But that's why a lot of stuff is stopped, by the way, okay? With development work has stopped. That's why when we did the tent meeting, you just saw that little rough end of the site plan, because they can't go any further. I've said, no, we can't spend any more money, okay? Jerry?
80% is 82 people.
No, actually, it varies because it depends on the par values of the people that vote, right? So I did the analysis, and I think the minimum number it takes to get to 80%, I think is 84 people. And yeah, and the maximum is 92, if I remember correctly. Okay? Depends. If you get all the 2 bedrooms and then you start getting 1 bedrooms, then you get there quicker than if you start with all the 1 bedrooms and then you go to the 2 bedrooms, right? So it just depends on the par values and who comes in and votes. Okay, so if you've got really high par values, you should vote sooner. If your condo fees are really high, come and vote. Anybody else? Okay. So there's one final point I want to address, or points, I guess, that I want to talk about. And it's sort of the elephant in the room in a way. So we talked a lot about people were not very trustful of Carl and that process, and I think we've addressed all of that pretty well at this point. But there's a lot of stuff going around. Somebody even actually sent me an email about this. A lot of people going around saying that we're forcing this on the owners, that somehow the board is corrupt in some way, and we're getting money under the table, or I'm getting paid off by the developer, and I'm controlling the board, and So I just want to put that on the table. Here's the reality. I did not get on the board in 2016 to do this. I got on the board, as Cynthia will tell you, who was the president at the time, I got on the board to address the problem of the occupancy requirements for landlords that was preventing FHA financing loans. Because I was trying to get my loans, my condo refinanced, and I couldn't get FHA financing because of that clause. Well, that turned out to be more difficult